This audio for you guys now. Again, the alleged gunman in court. Go ahead and listen. We only have the audio.
Good afternoon. Judge Paul Christian. This is a time and date set for the initial appearance of State of Arizona versus Stephen Jones. And before we get started, I want to let both sides know defense counsel is on the phone from Phoenix. And as to the county attorney, we have a limited amount of time on the video because of other scheduling issues. So I intend to allow both sides approximately 10 minutes to be heard on conditions of release. And so while I go through the initial appearance script, you may highlight what you think is most important to get on the record as far as conditions of release. All right. Today's date is October 9, 2015. It's 1:24 p.m. The purpose of this hearing is for the initial appearance of Stephen Edward Jones. The record will reflect he is present via video in custody. Mr. Jones, the purpose of the hearing today is for your initial appearance only. You'll not be entering a plea today. This is not the time to argue the facts of your case. Today we're going to advise you of the charges against you, confirm your mailing address. We're going to confirm that you do have private counsel retained. We're going to determine your release conditions and bail and advise you of your next court date. I'm going to be asking you for a current and correct mailing address. It's important for you to keep the court apprised of your current and correct mailing address at all times. Failing to do so could result in your arrest because you won't be notified of things that are going on in your case. This is a criminal proceeding this afternoon, therefore you have certain constitutional rights. Please pay attention while I go over your rights with you. You have the right to know the charges you're being charged with. You have the right to remain silent. This proceeding is being tape recorded, and the tape could be made available to the prosecutor. In fact, there is a prosecutor present in the courtroom today. You have the right to an attorney. We've received a notice of appearance from an attorney in Phoenix minutes ago, and also I know that the public defender has been with you this morning. If at any time you cannot afford private counsel, you can ask us to appoint a public defender for you, but we will consider the notice of appearance notice that you've retained private counsel at this time. You have the right to be present at all proceedings that take place in your case. You have the right to go to trial on your case, and in this case you'll have the right to a jury trial as opposed to a bench trial. If you'd like a jury trial, it's your responsibility to make a request in writing asking for a jury trial. We don't set it that way automatically, and you need to make your request at least 5 days before the case does go to trial. Whether you have a bench trial or a jury trial, you'll have certain rights during your trial. And the most important right you'll have is the right to confront and cross-examine anyone who testifies against you. But you also have the right to call your own witnesses to testify for you and to compel their attendance by way of subpoena. You have the right to present your own evidence during trial, including testifying yourself or retaining your right to remain silent during trial. If you go to trial and get a decision that you're not happy with, you'll have the right to appeal that decision, but you must do so in a timely manner. You are being charged with 4 felony charges. Therefore, you have the right to a preliminary hearing. If you're held in custody today and you request that hearing, it must be set within 10 days. If for some reason you are out of custody and you request it, it must be set within 20 days. If you're not a citizen of the United States, it's important for you to understand that if you plead guilty or are found guilty of any criminal offense, it could result in your deportation, could interfere with your immigration status, and prevent you from getting legal status in the future. If you're released today without a bond, you're going to be required to sign a promise to appear at your next hearing. If you then fail to appear, the proceeding will take place without you and an arrest warrant will issue. If you're released today on the condition of posting a bond, and you're able to post that bond and be released, but you then fail to appear at your next hearing, you'll forfeit your bond, the proceeding will take place without you, and an arrest warrant will issue. Mr. Jones, would you state your full name for me, please?
Stephen Edward Jones.
And you're currently a full-time student at NAU?
I'm a student at NAU, but I'm below the credit requirement for full-time.
And do you work in addition to going to school?
Could you repeat that, please?
Do you work in addition to going to school?
No, sir.
Did you hear me go over your constitutional rights?
Yes, sir.
Do you understand those?
Yes, sir, I think so, sir.
So you have 4 charges against you. You're being charged with first-degree homicide, which is a felony, and 3 counts of aggravated assault being charged as felonies. Do you understand the charges?
Yes.
And I'm not going to appoint a public defender for you at this time, as we have received a notice of appearance from your counsel. Do you understand?
You're not going to appoint a public defender for me?
No, we received a notice of appearance from an attorney in Phoenix. Sir, are you on the phone?
Yes, I am.
And would you state your appearance, please?
Yes, this is Burgess McCowan on behalf of Stephen Jones.
And it's
Okay.
McCowan.
Correct.
And Mr. McCowan, I'm going to give you the first opportunity to be heard as far as conditions of release.
Thank you. As you heard, Stephen is a lifelong resident of Arizona. He's also a student there. He has no prior criminal history, traffic offenses. Obviously, these are very serious charges. So he doesn't have his parents actually in transit there now. And they would certainly assure his parents he has no other place to go. He's not a flight risk. So we're asking for a third-party release to his parents.
All right, thank you. And for the state?
Thank you, Judge. Anna Bark for the state. I know we have just a few minutes, but I wanted to talk about some of the law and some of the facts in the case. With me also is Sergeant Mike O'Hagan from NAU and Erica Padrick from Victim Witness. She also has some statements that she wanted to relate to you from the victims, if that's okay. Just as a matter of law, Judge, this offense, the charge of first-degree murder is not bailable under ARS 13-3961. It says a person who is in custody shall not, no, there's no discretion there, shall not be admitted to bail if the proof is evident or the presumption great that the person is guilty of the offense charged, and the offense charged is a capital offense. Obviously, first-degree murder is a capital offense under our statutes. So really, Judge, you just need to determine that the presumption is great that he is guilty of the charge of first-degree murder. And just in summary, and I will note that the investigation is ongoing, and I'll just make a cursory kind of a summary of the facts in this case. But earlier this morning, the defendant, who was an NAU student, got into a confrontation with members of another fraternity, also at NAU. The confrontation began, as I understand it, as a verbal confrontation, then escalated to physical, but nobody had any weapon except for the defendant when he introduced a .40 caliber handgun into the fight. And the confrontation began on one side of the street, traveled across the street to an adjacent parking lot near Mountain View Hall on NAU campus. And it was at that point the defendant ran to his car, retrieved his gun, and then went back to the fight. I just want to be clear that there is no indication of self-defense here. The defendant had retreated from the fight, he obtained a gun, and then he went back into the fray. It was at that point that he began firing at the victims. 2 bullets struck the murder victim in this case, one to the chest, another to the shoulder. Several other bullets struck the crowd in that same area, seriously injuring 3 others. Those 3 were then taken to FMC where they were treated. One is in critical condition even as we speak. The witnesses identified the defendant as a shooter. The defendant himself admitted he was a shooter. The blood evidence at the scene suggests he also shot the victims a substantial distance away from where he retrieved the gun from his car. And there were several statements by witnesses at the scene that contradict the defendant's clearly self-serving account to the police. Judge, the bottom line is the defendant shot 4 unarmed individuals, killing one of them. He had sufficient opportunity to reflect on what he was doing, and that is why he is charged with first-degree murder in this case. The state would argue the presumption is great that the defendant is guilty of first-degree murder as charged, and as such he must be held without bond. In the alternative, Judge, if you find that there isn't, we haven't met that burden, we'd ask the court to impose a high cash-only bond in excess of $1 million. If I could just have Erica Padrick, a victim witness, address the court this time.
Ms. Padrick.
Thank you, Your Honor. The first statement I have is from Nick Peering. They're all very brief, Your Honor. He killed my best friend, and I watched him die in front of me. He did this for no reason, and he needs to stay in custody. The second one is from Tracy and Jeff. They are the parents of Kyle Zintek. He killed someone, and he severely hurt our son. He should sit in there and think about what he did. And the final one is from Douglas Burrow, I believe is how you say the last name, Colin's father. He killed my son. He shouldn't be allowed to go anywhere and needs to stay in custody.
All right, thank you. It's going to be the order of the court setting bond at $2 million cash only. The next court date in this matter will be on Thursday, October 15th at 10 a.m. Mr. Jones, I'm going to ask you if you have any questions, but before I do, I want to advise you that it may be in your best interest to remain silent and discuss things with your counsel rather than putting them on the record. Do you have any questions for the court?
No, sir.
Great. Is there anything else from the state?
No, Your Honor, thank you.
Defense counsel, do you have anything else?
No, Your Honor.
All right, thank you. The court will stand in recess. Thank you for standing by. Good afternoon. Judge Paul Christian, this is a time and date set for the initial appearance in State of Arizona versus Stephen Jones.
All right, guys, that is a wrap on the audio of Stephen Jones's initial appearance in court. I know some of you may have just arrived, maybe just saw the tweet and were eager to listen to it. So what I'm going to do is I'm going to replay that entire clip over. One of the things I want to point out is it obviously sounds like Stephen Jones very, very emotional. There was a moment where his voice cracked when he was speaking to the judge. I want you guys to look out for that, listen for that. You can hear the emotion in Stephen Jones's voice. There's a lot of speculation as to what exactly went down last night, if alcohol was involved in the situation. It seems to be one of those situations where all of